James Thurston. Welcome to this side event on technology and equal access to justice for persons with disabilities. We're very happy to be here speaking with each other and with you about this topic. I'm with the Global Initiative for Inclusive ICTs, or G3ict, and we've been doing some work in this area with partners, some of whom are going to be a part of this panel discussion today. I'd like to start by thanking our partner on this specific side event, the International Disability Alliance, IDA, who are represented here today by one of its board members and the president of the World Blind Union, Frederic Schroeder, and he'll be speaking in a few minutes. We'll also be joined today by two other experts for our discussion. One is Laura Ruby, Director of Worldwide Accessibility Policy and Standards and Regulatory Affairs at the Microsoft Corporation, and Michael Stein, co-founder and executive director of the Harvard Law School Project on Disability and a visiting professor at Harvard Law School. We're meant to be joined by Gerard Quinn, the special rapporteur, but I'm not sure if he's able to join us. But if he is, my colleague Julia will let us know, because we absolutely would be honored to hear from Gerard. So on this topic of access to justice and technology, Article 13 of the United Nations CRPD specifically defines access to justice as a right for the more than 1 billion persons with disabilities around the world. However, we know that people with disabilities face obstacles in justice systems, both criminal and civil justice systems, and really throughout the justice system. So from policing to courts to prisons and jails, incarceration and parole. And these barriers, these obstacles result in them being denied their legal standing and due process guarantees, and create a justice gap, a lack of equal access to justice for people with disabilities. And we see this in every country, every region. People with disabilities have worse outcomes in justice systems than the population as a whole. Just with, I'm based in Washington, DC, in the United States. Here, we know from US Department of Justice data that the disability rate among prisoners in the US is more than 4 times that of the US population in general. The Washington Post, one of the leading newspapers here in the US, has been doing a multi-year study of fatal police shootings, and their database shows of all the police shootings over the past 5 years that 20 to 25% of fatal police shootings each year in the US are of people with disabilities. So we know that there's critical urgency to these issues around access to justice and finding some solutions, better solutions to access to justice for people with disabilities. In August, the UN Special Rapporteur released a set of international principles and guidelines on access to justice for persons with disabilities. If you haven't reviewed it, I highly recommend it. It's a very thoughtful and strategic approach to making sure that countries are living up to their commitments under the CRPD to Article 13 and Article 12 as well. That followed a previous report from the High Commissioner to the Human Rights Council on the topic. And these multilateral reports specifically call for technology as a solution to barriers to justice for people with disabilities. And we want to explore those possibilities and other possibilities here today in solutions and making progress towards greater access to justice. So we'll start with some short interventions by each of our experts on the panel, and then I will moderate a discussion among us. First to speak will be Michael Stein. He is the co-founder and executive director of the Harvard Law School Project on Disability. Michael?
Thank you very much, and greetings to many friends who I see listed in the participants list, to colleagues on the panel, and it's a delight to be with you today. James had mentioned the access to justice, the international principles and guidelines on it that were released, and it's important to underscore his initial comment that this is not only the great work by the special rapporteur, Kata, who convened expert groups, but also is reaching across the UN system and globally. So the Secretary General will be submitting a report on progress under these principles. The principles have been endorsed by the International Commission of Jurists. They've been endorsed by IDA, which is co-sponsoring this panel, and by the UN Development Program. So it's a far-reaching set of principles. I'd also like to just note quickly that it's not simply, in quotation marks, Article 13, access to justice, but inevitably it brings into question and invocation Article 12 on legal capacity. The idea that one can represent oneself is inextricably linked to the idea of having equal access to justice. So there are the 10 principles, which I'll go over quickly and then offer some remarks. Just to go down the list, and you can find these online, readily accessible. Principle 1, again, goes back to Article 12, that all persons with disabilities have legal capacities and that will not be denied access to justice on that basis. Principle 2, that facilities and services must be universally accessible to and ensure equal access by people with disabilities. Principle 3, that all persons with disabilities, including children, have the right to appropriate procedural accommodations. And that's been a huge issue, not just with children, but our colleagues with intellectual and psychosocial disabilities, on having information facilitated and transcribed to them. Principle 4, persons with disabilities have the right to access legal notices and information on a timely, accessible manner with others. Imagine if you're a person with a disability and you miss a temporary restraining order or an emergency injunction because you could not read or have access to the information otherwise. Principle 5, that persons with disabilities are entitled to all substantive and procedural safeguards, both in international law and at the necessary domestic level, and that states must provide accommodations. Accommodations are there because we began without universal design principles, and the systems must be modified in order to allow equal participation. Principle 6, that persons with disabilities have the right to free or affordable legal assistance. This, of course, is a right which we talk about for being able to stand equally in a court and in other justice areas. Principle 7, that people with disabilities have the right to participate in the administration of justice on an equal basis with others. So we often think in shorthand about access to justice as being parties or defendants, but there is also an entire spectrum of areas, including administrators, juries, judges themselves, for which people with disabilities could and should have equal access with others. Principle 8, that persons with disabilities have the rights to report complaints, initiate legal proceedings, human rights violations, and to have them investigated, something I will come back to in a moment. Principle 9, effective and robust monitoring mechanisms must play a role for the equal inclusion of people with disabilities, again, something I'll come back to in a moment. And that principle 10, all of these things must be done in conjunction with awareness raising and other affirmative measures. James had mentioned that many of these principles will invoke some of the modern and marvelous ICT provisions that are out there. And we're seeing, by the way, now in the context of COVID, how justice systems have been converted to virtual systems where such technology exists. And it's an interesting note because courts, which previously said that everyone must be physically present, that justice could never be served unless people were physically present, now see that people do not need to always be physically present, and that doing things virtually as a matter of accommodation, in this case because of COVID, but in the future also because of various disabilities, is not only a viable measure, it's one that is necessary. But what these principles also look to is very much a top-down kind of approach. What states need to do in order to ensure that people with disabilities have equal access. And that is entirely correct and appropriate, and I endorse it as well. But what it doesn't go to, I think, sufficiently, with due respect, is the culture and process that needs to be involved in order to ensure that all court officials, including those with disabilities, because they should be employed just like everyone else within legal systems, can properly access justice. And so two of the areas that I think need to be highlighted as an addendum to the principles is the role of non-state officials. Let me give you two very practical examples. One would involve national human rights institutions, which are neither state nor civil society. For many years, about a dozen or so, I supported the South African Human Rights Commission and worked with them on a number of different projects, always, of course, pro bono, which is my mandate. We must recall that one of the very early cases brought to the South African Human Rights Commission was initiated and facilitated by the legendary Charlotte McLean and Schlappo, now again back with the World Bank, and it involved access to justice. It was a very simple, strong case of a lawyer who used a wheelchair named S.D. Mueller, who could not physically enter into the courts in South Africa in order to do her job as a lawyer. And the commission achieved a settlement with the government of South Africa. This is roughly 1999, I would say, 1998, 1999. We are now in the year 2020. And in those 20 or so intervening years, the South African Human Rights Commission has done nothing, and I underscore nothing, to enforce that settlement agreement. Nor have they looked more broadly at the issue of access to justice. So not just persons in wheelchairs, and I say that as a person in a wheelchair who is a lawyer, but also what about our friends who are deaf and hearing impaired, those of us who have psychosocial disabilities, and so on. It's one of the reasons that I've stopped working with the South African Human Rights Commission. It was a low-hanging fruit. It was easy enough to forward, but this is a role for a non-state agency that could easily and surely been forwarded. Here's another example, and that involves the role of civil society. Civil society, and here we really mean disabled people's organizations, DPOs, need to feel like they have the right to enter and access justice and be knowledgeable about justice. We did a study, one of my PhD students, who's marvelous, Tafadza Roko, did one in Zimbabwe, where he's from, on access to justice by women and girls with disabilities after having been sexually abused. This was in rural Zimbabwe. It involved focus groups. And among the interesting aspects of that study was that these women and girls had no concept of a CRPD, had no concept of a right, a human right, a civil right, other than a moral right to access justice. And were not invoking the CRPD or invoking national level laws when they complained, rightfully so, about the inaccessible police stations, about the way that law enforcement personnel did not engage them in a sensitive and inclusive manner, the way that healthcare services did not provide adequate services or embrace them, the challenge to actually get to court from a rural area in an inaccessible bus over many hours and miles, the cost of doing so, and so forth. And so one aspect that's not included, I believe, to a sufficient degree within these very marvelous guiding principles is the roles of civil society believing that they have an investment in and a right to bring forward their wrongs and claim their rights. So that is something I think we need to think about moving forward as far as access to justice. On ICT, just because we have not pointed a finger at ourselves, I will note that for many years, I was on the Americans with Disabilities Act Committee of the US National Center for State Courts. And there, working with all the chief judges and justices of the US, there was a point even as late as 2005, despite 15 years of the ADA, 40 years of the Rehabilitation Act, where the chief judges and justices doubted that persons with disabilities under the ADA had a right to equal access to courts. They were happy with programs doing awareness raising among police and other court officials regarding access to justice. They were happy with pilot projects, but they did not feel committed to the notion of making the US state level courts, which is the vast majority of courts, accessible to people with disabilities. They eventually changed their mind, in small part due to perhaps to my advocacy, but in large part due to the Chief Justice of Maryland being an African American who had gone to the Supreme Court as a teenager challenging Baltimore's racial segregation, and by the Chief Justice of Hawaii, who was the first Asian American to be the Chief Judge of the state court. I mention this because it points out, one, the lack of awareness among many judges themselves, and two, it points out that we need broad coalitions. We need those who are in the race area, in the gender area, in the LGBTQI area, all to join together in support of the notion of access to justice being good for everyone and being something on which we can all agree and work towards together. So that is my 12 minutes. I'll stop to keep us on time, and I'll look forward to engaging you with.
Fantastic. Thank you so much, Michael. And thank you for making that important linkage to Article 12. And also I'm glad that you brought up and mentioned COVID and the implications of the current pandemic, the global pandemic. And a colleague of ours, I've heard her often say that crises like this, emergencies like this, make more clear those things that we already know and make them much more explicitly clear to us. And I think the pandemic has showed us that the digital transformation of society and certainly the digital transformation of courts and justice systems is presenting both opportunities, real opportunities, as you mentioned, but also potentially some risks that need to be paid attention to as well. And so with that, what I'd like to do is segue into a little bit more discussion of that. In fact, there was a question about digital barriers, and I'm going to start to talk about that. Also, I'd like to encourage participants to use the Q&A. We're happy to take questions, and we'll have some more open time for questions after each of the individual presentations. But maybe segueing a little bit into an even deeper digital examination of the digital aspects of access to justice. 2 years ago, we partnered with IDA to survey its members around the world on this issue of whether or not courts are achieving digital inclusion. What are the implications of the digital transformation of courts and justice systems around the world? And so we got responses from more than 65 different organizations in 34 countries. These are our IDA members. 11 of the respondent organizations were in developed economies. The remainder, 23, were in developing economies, so an interesting mix of global north and global south. And we really did try to dig into this issue of our courts today providing equal access to justice, and what does that look like from a technology perspective. So the results describes, I think, some important challenges, but also some real opportunities. There are some really interesting findings, I think, in there, and I want to just share some of those with you. I'm going to try now to pull up some of the data, which I'll talk through and describe. You can let me know if it's working, and try to go to presentation mode here.
It works, change.
Okay, great. So I mentioned we did this in partnership with IDA a couple of years ago, and asked several questions about access to justice in general, but also really tried to get into some of the technology implications of the digital transformation of courts and justice systems, and what does that mean for these barriers and opportunities. So what we heard from the respondents, the IDA members, is that today people with disabilities do not have equal access to justice around the world. In fact, the overwhelming majority of the respondents of the disabled persons organizations, IDA members, 85% said that persons with disabilities don't have equal access to justice. 11% of them said that they do, and 4% were unsure or unaware of what the current state of access to justice in their country was. The disabled persons organizations in the developing economies were more likely to say, no, there was not equal access to justice, and slightly higher there. We also asked about what kinds of judicial activities do persons with disabilities not have full access to. And so we had a range of options, and then also the ability for the IDA members to specify different options. But the top ones that we heard, the kinds of activities that people with disabilities are being prevented doing, and we heard some of this from Michael's presentation a minute ago. At the very top was accessing information, which is critical to any sort of judicial proceeding or either civil or criminal. Just getting good access to information and timely access. So 93% of the disabled persons organizations identified that as a real barrier, a real kind of activity that was not happening in a way that supported equal access to justice. Participating in these broad range of roles that Michael also talked a little bit about, whether it's and this was in a court setting, so it could have been a defendant, a plaintiff, a judge, a juror, a witness. 81% of the IDA members talked about not being able to participate in these critical roles in the courts and justice systems. A third top activity that was problematic today for people with disabilities was filing cases and tracking progress on those cases, really being actively involved in your case, whether it was civil or criminal. And 70% said that was a real problem activity for people with disabilities. We also, going to Martin's question in the Q&A, sort of what are the top barriers that people with disabilities were seeing in courts and justice systems? And here, the top one was that justice personnel just are not trained across the board in justice systems, from policing to courts to prisons and jails. 88% of the IDA members of the DPOs mentioned that justice personnel were not trained. They're not trained on disability. They're not trained on accessibility or on accommodations. And that's a real problem, obviously, for active participation for people with disabilities. 81% said, and this goes to the access to information, which is also really highlighted extremely well in the High Commissioner's report to the Human Rights Council on Article 13, and also on the Special Rapporteur's principles that Michael talked about. 81% said that information was not provided in alternative formats like Braille. 70% said that documents that were critical to the activities within the courts were inaccessible, so not readable by a screen reader, for example. And there were many other barriers that were listed as problematic. Interestingly, we also asked the respondents, the disabled persons organizations around the world, what role can technology play? And we tried to dig into that quite a bit. And this is one question, frankly, where I was a bit surprised by the numbers, where 89%, nearly universal, the IDA members said that they do believe technology can play a positive role, can help in addressing these barriers to technology, the kinds of barriers and activities that I just mentioned, that there is a role for technology. And as Michael mentioned, and I think we'll hear more in a bit from Laura, that the COVID pandemic has shown us some innovative ways of leveraging technology to make the justice system work. And can we be thinking about ways to apply that to ensure better access to justice for people with disabilities? And again, this survey was well before the COVID pandemic, but certainly there was an optimism there, I think, of DPOs, of persons with disabilities, around the potential power, if well thought out, of using technology to support greater access to justice for persons with disabilities. This also, I think, goes to an important point, Michael, that you were making just a minute ago about the role of civil society, and I'm guessing that Fred will also be talking to this. We asked the IDA members, these disabled persons organizations, sort of what is their role? How are they engaged on this topic of access to justice in their country? And just half of them said that they are consulted on improving access to justice, which is not a great number. Ideally, that number, there'd be active engagement of disability organizations with decision makers around access to justice issues and how courts are managed. 42% said that they weren't engaged on improving access to justice, and 8% weren't sure or weren't aware. So clearly there's a lot of opportunity there. And again, I think the High Commissioner's report to the Human Rights Council and the principles laid out by the Special Rapporteur get at this as well. how can we need to be engaging persons with disabilities and civil society organizations more aggressively in thinking through how technology, thinking through barriers to justice in general, but also how can technology play a more positive role in supporting greater access to justice. So from that set of data and some other focus groups that we had done, G3ict laid out some recommendations. These are all on our website, and we have an access to justice page that collects all of our work in this space of technology and access to justice, and we'll share that in the chat. But we, in one of the reports that we put out as a result of this work, there were several recommendations, which actually interestingly, and I think in a very positive way, align quite well with the Special Rapporteur's principles, about really pushing justice systems just to be more aware of the digital transformation of courts and justice systems, of disability, and the role that technology and accessibility can and need to play. The importance of procurement as courts, and we'll hear more about this and talk more about it, as courts are undergoing this significant digital transformation. How can they be using the power of the purse to make sure that all of their technology that they're buying and deploying to support these justice systems and activities, including courts going completely digital, making sure that that's accessible technology and accessible technology deployments. Mainstreaming inclusion into legal frameworks around courts and justice systems. We think there's a real need and opportunity to, in countries and collectively all of us, identify and define what are good practices when it comes to technology and supporting greater access to justice, and using those good practices to create roadmaps for courts and justice systems. And we'll talk a little bit more about what some of those might be. Training and guidance, and we've done some work with courts around the world, and clearly this is a pain point that needs real attention and we certainly saw in the results from the IDA survey, there's a real need for across the board in courts and justice systems training personnel on disability, on technology, and on accessible technology. Supporting more inclusive innovation. There are a lot of legal tech firms out there. They're creating these amazing new solutions and incubators and accelerators that are being offered to, sold to, and deployed by courts and justice systems. But too often those exciting innovations from a technology perspective, they're very exciting, but too often they're not, these legal tech innovations are not accessible. And so we need to figure out a way to infuse that innovation ecosystem around legal tech with a greater focus on accessibility and also greater participation even within the innovation ecosystem of people with disabilities. And Michael, I think you touched on this as well. Another recommendation is really involving multilateral organizations in a much more productive way. They are in many ways funding the transformation of justice systems around the world. They need to have a much stronger focus on disability and accessibility as part of their work in improving justice systems around the world. And then finally, involving persons with disabilities, which I think will be a constant theme throughout our conversation today. And really go into that core principle of the CRPD, that as we're talking about the transformation of courts, as we're talking about the digital transformation of courts, people with disabilities need to be at the table as a part of those conversations with justice systems. So we'll paste information and the results of this survey that we did with IDA in the chat. I'm going to stop sharing. And then I think it's a good opportunity to move to our next speaker, Laura Ruby from Microsoft, who's going to talk about these issues from a very clear technology perspective. Laura?
Thank you, James. And thanks to all my fellow panelists and participants. As James said, I'm Laura Ruby. I've been at Microsoft for 20 years, all of those years working on accessibility and disability policy. And that gives me the privilege of working with governments, with nonprofits and disabled people's organizations, industry, and my Microsoft colleagues globally. I wanted to talk a little bit today about inclusion and technology. And I wanted to pick up on one of the points that Michael made about culture and the need for courts and justice systems to really make a cultural change around inclusion, not just be aware, but change the culture And in doing that, I want to talk a little bit about Microsoft's mission and how we think about inclusion. At Microsoft, we're very passionate about creating products and services that help people with disabilities unlock their full potential at work, at school, and in their daily lives. We are making investments across our business, and we believe that it's imperative for all organizations to create cultures of inclusion. Our mission at Microsoft says that we want to empower every person and every organization on the planet to achieve more. And that mission, again, it really extends beyond just our products and services to the culture of our workplace and the approach to inclusion in everything we do, including how we're helping other companies, academic institutes, nonprofit organizations, and government entities be more inclusive too. So we believe that governments have a role to play in ensuring that they purchase, develop, and use accessible information and communications technologies to better support citizens, increase access to public infrastructure, and to create more inclusive government workplaces. And Michael, you touched on that point too, that making sure that our courts and justice systems are inclusive workplaces, not just inclusive to citizens, but inclusive workplaces for employees with disabilities. So over the last 3 decades, we've learned that when technology is inclusive, we can connect people and information in incredible ways. A lot of you know our Chief Accessibility Officer, Jenny LeFleury, and something that she often says, she says, progress on accessibility is real, but there is a lot more work to be done. So to enable this transformative change across organizations, accessibility needs to be a priority for all of us. Microsoft has had the pleasure of working with G3ict for a long time. We have a long history of collaboration, and we have a shared understanding of how policy and technology can work together to benefit people and organizations. When the convention was adopted over 10 years ago, Microsoft, we joined forces with G3ict to explore how we could increase human rights through accessible technology. We together believed that we could help governments and the people with disabilities that the governments serve take advantage of existing accessible technology and then better inform the innovative emerging technology of tomorrow. So since then, we've worked together on a number of technology and policy initiatives, including G3ict's Smart Cities for All initiative. We recently collaborated with the World Economic Forum and G20 on the creation of a model accessibility procurement policy. And we've been working together on access to justice for people with disabilities. G3ict approached us before COVID to talk about access to justice. And that was just as courts were starting to go digital, or as we say in industry, as courts were digitally transforming. Together, we wondered if court and justice systems could leverage existing digital technology. And you've been hearing about all the remote hearings that courts are having. So we wondered if some of our technology, like Teams, could serve people with disabilities more effectively and increase access to justice. So before we talk more about technology, let's take a minute to talk about what it means perhaps for a court to digitally transform. Most court systems are still primarily paper-based. And I wanted to share with you an example of what it means to be paper-based. So before moving to a digital justice platform recently, the judicial systems in the United Kingdom generated roughly 1 million pages of documents per day. That's 365 million pages a year. So that's a lot of paper. So when these courts digitally transform, they move from paper documents often to record systems with digital documents and digital record systems. they implement digital case management systems. They may start to use voice and video conferencing technologies to enable remote hearings. They might use speech-to-text technology to create transcripts. And instead of requiring people to go to a physical location for transactions like paying a fine, maybe for a traffic ticket, they might deploy interactive web systems that people can use remotely from their homes or businesses. So back to the question that we in G3ict had, could these innovative digital technologies that courts are adopting be used to increase access to justice for people with disabilities? Well, that question led us to more questions. Are courts and justice systems even aware of assistive and accessible technology? Have they considered using the newer digital technologies to accommodate people with disabilities? Do courts know if the products they are purchasing and using have built-in accessibility solutions that could be used to increase access to justice? So clearly we had a lot of questions we needed answers. In 2019, we partnered with G3ict and the International Association of Court Administrators to survey its members, as well as other specialists working in or with courts about technology and access to justice. So our goal was to determine if courts and justice systems worldwide included a commitment to ensuring access to justice for people with disabilities as part of their digital transformations. Our key finding was this: courts worldwide are investing in technology, but they lack a focus on accessibility and inclusion. So let's break this down a little bit. In 48% of cases, courts do not or only partially meet requests for accommodations for people with disabilities. 38% of courts provide low or a very low level of access and inclusiveness of technology deployment for people with disabilities. 60% of courts have budget allocated for digitization, but less than 10% specifically allocate budget to funding for ICT accessibility and digital inclusion of people with disabilities. More than half of the respondents reported their procurement department and officials include accessibility infrequently as part of the procurement process and only in very general terms. Some of the major obstacles that they reported to achieving more accessible technology and greater inclusion in their courts were insufficient financial resources, lack of awareness about disability, and lack of knowledge about accessible technologies. So now let's talk about the positive results from this report, from this survey. So on the positive side, similar to what you heard from James about the IDA survey, the message from these court administrators was that nearly all of them were open to using technology as a solution for access to justice. And the majority thought that technology could improve access to justice for people with disabilities, but they clearly indicated that they needed help for becoming more accessible and inclusive. So since this study was completed, the COVID-19 pandemic has rapidly accelerated the digital transformation of courts. I was looking at a really interesting website a couple of days ago. It's remotecourts.org. And they have collected articles about courts going remote from all over the world. So courts that are, as I said earlier, digitally transforming. And I'm just going to read you a couple of the headlines of the articles that they posted just for the last like 5 weeks. And that will give you a sense for kind of the breadth of acceleration that these courts are experiencing. So one is Illinois Supreme Court allows remote jury selection. Brazilian National Council of Justice approves move towards 100% digital procedures. The Swiss government extends use of video conferencing for court hearings. And this is one I like a lot. English High Court judge reflects positively on technology use in remote proceedings. So some of these, I think, judges are saying, we didn't think it was going to be okay, but now we think it's a positive thing. So as all these courts are moving in this direction, there's no time to lose in us looking at how we can address accessibility as part of these court digital transformations. So last spring, Microsoft, we worked with G3ict to create the Inclusive Courts Checklist, and it's up on G3ict's website. So it provides courts with guidance on how to include accessibility in their organizational planning, their budgeting, their purchasing, and it gives them a sense of how they can leverage existing technology to support greater access to justice for people with disabilities. It has 10 core capabilities that courts should develop to support digital transformation. It provides another 36 steps or enable activities for these courts to be more inclusive. And this checklist is just one tool, but it can help courts and justice systems start moving to, be more inclusive. But in order to enable real transformative change, accessibility has to be a priority for justice organizations and for all of us. As James mentioned earlier in the survey of disabled people's organizations, the IDA survey, we absolutely must address the underlying issue of ensuring that people with disabilities have access to technology, but also we have to make sure they have access to broadband and equipment, or they won't be able to take advantage of some of the digital technology that courts and justice systems are putting in place, like being able to remote into a hearing. So there's a lot to be done, and at Microsoft, we feel like we are still learning about and growing our own culture of inclusion. But one thing that we do know to be true is that digital transformation is just not simply about technology. It also requires organizations to re-envision their existing business models or their justice models and embrace a new way of bringing people together, of using data and processes to create value and inclusion for everyone. So we're very grateful to be a part of helping courts do the same. Thank you, James.
Great. Thank you so much, Laura, for that perspective. I think it's really helpful, the examples you gave about what does the digital transformation of courts actually look like in different countries around the world, different geographies. I think it helps us get a better feel for where the risks and the opportunities are when we're talking about access to justice. I'm also thankful that you talked a little bit about the second survey that we did, and we did this in partnership with you and the International Association of Court Administrators. And these are the people who are making day-to-day decisions about, including technology deployment decisions about how courts are run around the world. And so I think it becomes clear when you look at that data, the responses from this survey of court administrators, how a clear accessibility gap can become a gap, a justice gap as well, if we're not thinking about it and managing it well. So thank you for raising both of those points. So finally, what I'd like to do is ask our partner from IDA and the president of the World Blind Union to make some remarks. Fred Schroeder.
Well, thank you, James, and it's a real pleasure and honor to be with all of you today on this very important topic. Just before I begin, let me just acknowledge that we have appreciated, that is the World Blind Union, we've appreciated very much our own ongoing collaboration with G3ict. We have a representative from the World Blind Union, Hans Legrelius, who is a member of the G3ict Smart Cities for All program committee, and that's been a very productive collaboration. So as you've heard, starting with the overarching policy, the UNCRPD calls on justice systems to be equitable or accessible to people with disabilities, as do the Sustainable Development Goals. Most recently, I have been very pleased with the special rapporteur's policy or principles and guidelines that reinforce the idea of equity as far as access to the judicial system. But statements of policy are only the beginning. Now, when I say that, that does not mean they're an unimportant part. Unless we have a philosophical or overarching commitment to equity, to full accessibility, then we do not begin to address the practical steps needed to implement that vision. And so vision alone or aspiration alone is not enough, but it is a powerful and meaningful beginning. It sets a standard or a goal for states parties to strive to attain. So what does it mean to have an accessible judicial system? Well, you've heard many examples already from previous panelists. And as I listened to the panelists, I thought about my own experience, the experience of our members, and through the International Disability Alliance, the experience of people with very varying types of disabilities and how they are treated by the justice system. Recently, there was a man with an intellectual disability in South Africa who was shot and killed by police on the presumption that he was not following instructions. So these types of occurrences or barriers or miscarriages of justice, if you will, these are real. In my own life, there was a time when a bank refused to rent a safety deposit box to me on the basis that as a blind person, I could not sign on my own behalf. So this gets then into the area of legal capacity, and it's a serious area. Our members report in many countries that that blind people and others with specific types of disabilities are not allowed to enter into contracts, can't purchase property, can't rent an apartment without someone else representing the commitment on their behalf. All of this points to a problem, but a problem that stems from a fundamental disregard for the ability of people with disabilities to speak for themselves and to guide their own destinies. In other words, it comes from public misunderstanding. It comes from prejudicial attitudes. And without sounding perhaps bitter, I'll just say very bluntly that society generally feels perfectly free to take charge of people with disabilities and assume that they, the predominant society, know better what we need and what is reasonable than we ourselves. There was a woman here in the United States, a young blind woman, a single mother having her first baby. She was, I believe, 21 years old. And based on nothing more than the fact that the young woman was blind, a social worker was called to the hospital, and the social worker took custody of the newborn baby. And the social worker was quoted in court documents as saying, "I could not in good conscience send this baby home with a mother who is blind." That was the standard. That was the legal standard. And the court granted temporary custody to the state and approved an order only allowing, and by the way, the social worker and the state argued that there should be no visitation allowed during the time from the preliminary decision until a final decision of custody could be rendered. Fortunately, the court allowed supervised visitation. Again, based on what? Based on data, experience, documented evidence, based on nothing more than assumptions, preconceptions about people with disabilities and their capacity. Fortunately, due to substantial advocacy, the court eventually restored custody of this baby to this young blind woman. but it was 57 days. So she was separated from her newborn for 57 days based on nothing more than a social worker's good conscience standard. So this is real. This touches people's lives in dramatic and powerful ways. So where does technology fit in? I started, I think, by describing some of the real challenges to make the point that accessible technologies are not just nice things to do for people with disabilities, not just some sort of kind of charitable act or something that makes people feel good. These are critical components of ensuring an accessible and equitable judicial system for people with disabilities. People must have materials in alternative formats. Sign language interpretation must be available. The needs of people with psychosocial disabilities, intellectual disabilities, the whole range of people with disabilities. First, they must be respected as human beings with equal rights, and the supports, the technology, the access must then be the outgrowth of that change in public attitude. So as we work toward developing a standard or some sort of definition to what an accessible judicial system would look like, we have to start with that very fundamental principle in the UNCRPD: nothing about us without us. An accessible judicial system must start with consultation with people with disabilities, DPOs, that represent the authentic voice of people with disabilities, that know what accessibility genuinely looks like. This is, again, not something to be done at the at a casual or superficial level, but this has to be integral to the development of a standard or policies and to the monitoring of their effectiveness. I know time is limited, but I'm reminded of a situation I was involved in a number of years ago, where a state government agency wanted the input of the disability community, and yet expected people to travel, to stay overnight, to provide their input without any support. That is to say, the agency, although it said it wanted the input of people with disabilities, it didn't pay for it. And the director, the morning that the consultation began, said, "Oh, I'm sorry that we don't have the funds to bring all of you here, but we appreciate you coming." And I thought to myself, yes, and if your roof starts leaking, are you going to call the contractor and say, "I'm sorry we don't have funds to pay you, but we expect you to come and perform an essential service"? In other words, we have to be taken seriously. We're very pleased, both the International Disability Alliance and the World Blind Union, which I represent, we're very, very encouraged by this initiative, by the idea of really thinking through the barriers to full participation in the justice system and to finding solutions that can be implemented, can be replicated around the world. Thank you for having me.
Fred, thank you so much, Fred, for those remarks and for your partnership with G3ict on this and in other issues. So at this point, what I'd like to do is move into some discussion. And Fred, I think I'll since your remarks are very fresh in our minds, start with a question for you. You gave I think some compelling, visceral sort of examples of this. I'm looking for your language. This fundamental disregard for the legal capacity of people with disabilities around the world. Again, this isn't a geographic specific issue. It really is in every country a challenge. So I'm wondering if, from your work with your members, if the strategies that in this issue area of access to justice systems, on your sort of last point you were making about the fundamental CRPD principle of nothing about us without us, what kind of strategies would you recommend or suggest, or have you seen good strategies of engaging people with disabilities in this issue of justice? Recognizing that what we learned from some of our work with court administrators is that, and certainly we saw in our IDA data that people working in these courts and justice systems need training on disability and on accessibility. What are some ways to bring this together and to get that voice in there that is so critical?
So this may seem like an odd answer to your question, but I'm 63 years old. So when I grew up in the United States, we didn't have an Americans with Disabilities Act. And in 1990, the act was passed, and 30 years later, it has been a powerful force in transforming opportunities for people with disabilities in our country. It certainly has not solved all the problems. Now, why I mention my age is that when I was 30 years old, if there was some barrier to full participation, I felt as though it was a weakness in me. In other words, I felt it was the disability. I felt that denied full participation, denial of full participation was the inevitable consequence of my inferiority. And now when you look at 30-year-olds with disabilities in the United States, if there's a barrier to full participation, they don't feel inadequate in themselves as much as they feel angry that their rights are being compromised. And so the reason I say this may seem like a strange answer to your question, but I believe that first and foremost, access to justice, access to full inclusion across the spectrum, education, employment, and whatever area, it has to start with people with disabilities believing in their right and ability to guide their own lives, and to not view it as something that is a symbol of charity or kindness, but that it's a basic human right. With that foundation, then people with disabilities can begin advocating with national governments, with whatever the official structures or systems are, in demanding equal access, and not settling for the crumbs that fall from the table, but saying, I have as much of a right to live in this world as you do. And then demanding that the systems be put into place to safeguard our rights to the extent that others enjoy safeguarded rights. So fundamental in my mind is capacity building of DPOs around the world, giving people with disabilities dignity and the sense that they belong in this world as do others. From there, then you can begin to push your governments, your other systems to include us, and to include us in meaningful ways.
That's really helpful, Fred, and I think exactly on point. And certainly in general, in the work that we're doing around the world, we see the need and the benefit, frankly, of that capacity building in a very structured and committed sort of way, in bringing these different perspectives together and making sure that disabled persons organizations are able to be an equal partner at the table, which can be challenging at times when we're talking about, in many cases for G3ict, in the work that we're doing, technology-specific types of solutions and digital transformations, whether it's in education, of cities, of smart cities, or in the justice space. Michael, I'd like to check in with you on maybe something more positive of good practices in the work that you're doing in this space. Are you seeing we've talked a lot about the barriers and the challenges, but are you seeing any good practices that you think are worth replicating? And one of the recommendations that we put out there in our white paper on the topic is we've got to start cataloging these and getting them shared in different geographies around the world. But we'd love to hear maybe from you any good practices that you're seeing.
Sure, great question, James. And the world is thankfully full of good practices and full of marvelous DPOs working hard and making changes every day. Maybe I could throw out the example of Bangladesh, where my organization, the Harvard Law School Project on Disability, has been working for most of our 16 years. Come to hpod.org and see some of it. And to give you a quick snapshot, 2007, the country ratifies the CRPD. 2013, they pass a new national level law, which we were happy to contribute to. And there were some positive developments on access to justice, including working with BLAST, the largest public interest firm, and having them understand that disability was part of the agenda, creating an easy to read Bangla language for public interest lawyers for the rights of people with disabilities. But at the same time, the women with disabilities and the girls with disabilities that we worked with through the National Council of Disabled Women, through the National Grassroots Disability Organization, would report to us over and over again incidents of sexual violence and abuse, and then going to court and being told, but you're blind, how could you possibly testify? But you're deaf, you couldn't really identify the person. You have an intellectual disability, how can we rely on you? And this would go on over and over, and many of these instances are documented by the then UN Special Rapporteur, Rashida Manjoo, who is for the prevention of violence against women in her report to the General Assembly. Well, we had a small grant which we supported, and it was to create access to justice across Bangladesh through one of the provisions of this new national disability law. Whereas most of the judges and judicial referees and administrators had no idea that people with disabilities were authorized to bring cases, and neither did the people with disabilities. So over a 15-month period, we engaged in trainings of over 6,000 people with disabilities, of the court administrators and others in various of the 64 Bangladeshi provinces. We created, besides these trainings, awareness-raising devices, such as videos in Bangla, a folk song recording about your rights, an easy-to-read language document on how to go and get these rights done. And now what we're seeing, and you can go and check at disabilitybangladesh.org, which we are not controlling or just supporting, we have at least 22 complaints brought in 7 of these districts, and the DPOs there are very devoted and very focused on bringing more complaints, not just on sexual violence and abuse, but also on other forms of exclusion from society. So that's a wonderful example. With 1 minute, I could also tell you a funny instance, which was I was carried up the stairs to visit the Chief Justice of Bangladesh because there's no access to the court building. And this was a number of years ago. And we went to discuss the complaint that we had brought, which was sitting at the Constitutional Court, about people who were blind not being permitted to apply under an affirmative action scheme, under the quota scheme, to be judges. Because according to the Chief Justice, as well as others, judges had to be able to look at a defendant and notice their demeanor, all of which is considered rubbish under most scientific evidence that's now construed. And we had a very interesting and lovely conversation, and I talked about the exclusion of people with disabilities. And he said, well, how could you be excluded? You're here. And I said, well, I was carried up the stairs. And he never realized that his own courthouse was inaccessible. And so he said, well, when are you leaving? And I said, in 3 days. He said, okay, can you please pass by the courthouse on the way to the airport? And I said, okay. He said, you don't need to come in, just look on one of the sides. And I said, all right. And he wrote a judicial order to the Minister of Construction to put in a ramp. And 3 days later, as I was passing in my car on the way to the airport, there was a brand new all accessible ramp on the side of the courthouse. Now that's great, but it doesn't get us around persons who are deaf and hard of hearing, people who have visual impairments, those with psychosocial disabilities, those with intellectual disabilities, or the general notion of this very wise and lovely man that people with disabilities just could not be active participants at the highest level, let alone the lowest level of access to justice. So good practices everywhere, and we're looking forward to more.
Great, Michael. Thank you so much for those examples from Bangladesh, which really are easily replicated. I mean, those are things that courts and justice systems around the world could be learning from and doing. So great that you've supported the development of those and the sharing of those. I think the story that you mentioned about the courthouse and the justice really points to what Fred had talked about. Laura also talked about in her remarks as well, about this awareness raising and capacity building and training. And one of the good practices that is related to that I've seen was actually here in the United States. We did a focus group of courts and other parts of the justice system in the US state of Georgia, including the State Bureau of Prisons and others. And they talked to us there, the Bureau of Prisons, about how they every year train their staff, all staff get training on disability, which is critical because as I mentioned early on, and most of us know, people with disabilities are in the prison system at a much higher rate than you would expect based on the general population. And so that kind of training they had found was really useful in that setting. So useful, in fact, that they were at this time, this is about a year and a half ago, they had started thinking about, or had actually started planning to train, provide awareness raising and training for the entire prison population, the inmates and prisoners themselves, about disability and what it is, because they had been seeing problems related to directed at prisoners with disabilities. So which I thought was a pretty innovative and kind of progressive forward-looking approach to in that part of the justice system. Laura, I want to come back to COVID. You mentioned some examples of related to the pandemic of deployments, and I'm wondering if you think that, or if you're able to comment on, is Microsoft, are you seeing any impacts from this sort of shift or maybe acceleration of the digital transformation of courts and justice systems? Are you seeing any impacts at this point when it comes to people with disabilities?
Yeah, no, I can definitely speak to that. We have seen, the virus has definitely accelerated the use of digital technology everywhere, and it's really brought a focus on accessibility, because many or most of us are now using technology to work from home, to go to school virtually, and for social interaction. So all of this remote working and learning and information sharing, of course, can be more difficult if the content and the platforms are not accessible. From what we've seen, we think it's very, very critical that we focus on making sure everyone is included and can be productive, whether it's school or work, through use of technology. Through, I guess, within the first couple of weeks of quarantine, when everyone was kind of shifting and we were all learning how to work from home, our disability answer desk, which is there to help answer questions about accessible technology and solutions, they received 200% of the normal call volumes. We saw use of Immersive Reader, which is a tool that helps readers with learning disabilities, especially people that are needing to read in order to learn to go to school. There was a 560% use, and the captioning usage for Teams, which is our web conferencing and messaging platform, the captioning usage went way up. It was up 30% from a couple of months prior. So, along with the courts and justice systems, all shifting very quickly to remote, we saw these statistics as good evidence that people with disabilities that maybe had not used as much technology in the past were also shifting to learn how to use these technologies. So again, technology is definitely helping people connect and communicate and learn, but if it's not accessible, then people are going to be left out.
Fantastic. Thank you so much, Laura. And I think another thing that, as this colleague that I mentioned earlier on, this pandemic makes the things we know more clear. One of the other things is that if we're deploying accessible technology, it really is going to benefit everyone, whether it's in an education system or a justice system. So I think I'm just checking time here. I'd like to end with a question about policy and legislation. And Michael, I'm going to come to you first on that. But before I do, there is one other question about do any country-state reports before the CRPD committee or committee observations depict documented examples of digital access to justice? So I think and I'll let the other panelists speak to this, from my read of the country reports and the other materials around those reviews before the CRPD committee, I've not seen a lot of treatment of technology and the digital aspect of justice systems, but what I have seen consistently now for a couple of years, I think, is the committee focusing on buying accessible technology in general related to Article 9 and accessibility, which I think is a really positive development in a strong way of pushing whatever the sector is, whether it's justice or education, pushing them to be more inclusive and accessible from a technology perspective. But Michael, let's maybe end on this issue of policy and legislation. What kinds of policy and legislation do you think are needed or could be effective that would help move the ball forward, help support greater access to justice in general and or from a technology perspective? And Fred and Laura, I'll check in with you about weighing in on that question as well. Michael?
Well, I would just take a universal approach, and that is to understand that as we want to encourage societies to be democratic and inclusive with a small d, we want it to be democratic and inclusive for everyone. And so policies and laws that begin with universal design principles so everyone can be included, including those with disabilities, I think create a bigger political force and a bigger buy-in for everyone. And the same could be said for things like transportation or other issues. Make it a society-wide idea. What we just saw here in the US with elections, right, is that when we have accessible elections that include everyone, people with disabilities get included and swept in. When we have elections that try to exclude people, the most marginalized members of society get excluded. So access for all and inclusion for all.
Great, thank you so much, Michael. Fred, would you like to weigh in on any additional policy or legislative prescriptions that countries should be thinking about to support access to justice?
Yeah, as I mentioned earlier, we need a good, solid definition of what an inclusive justice system is. And once we know what it is, and Michael mentioned universal design, and I think that absolutely is correct. That's the starting point, that the system needs to be designed from the ground up, accounting for the fact that society is diverse in many, many respects. But once we know what an inclusive court system or judicial system is, then we need resources so that it's not just, when we can, we'll do X, Y, and Z, but that the resources then support the structure or the vision, support the technology that grants access and the physical design of the facility, et cetera. I think also, though, you need training. Much of the exclusion is attitudinally based, meaning that judges, courtroom personnel, etc., they don't necessarily have an understanding of what inclusion of people with disabilities really means or looks like. So you need some training. And finally, I would say, and I'm not suggesting this is an inclusive, all-encompassing list, but the other dimension that leaps out to me then is an evaluation or feedback mechanism to say, we've put these things into place. Now, are they working? Are they achieving the policy objective? So those would be my thoughts.
Thank you, Fred, so much. And I like the idea of coming back to what we've heard in our discussion today, but also even in the principles from the special rapporteur is this notion of monitoring and the need for that and feeding that back into ideally continuous improvement loops. Laura, any final thoughts on policy or legislative approach to making progress here?
Yeah, I think we really need to think about how we can get courts and justice systems to put procurement policies in place so that they start thinking about accessibility and talking to their vendors about it, so that as they are going digital, they are aware of and building technology infrastructures that can support everybody. I think that's something that's a really good foundation that then can be built on. But I think there are a lot of things we're going to need to do around the policy activities together as disabled people's organizations, as industry, as experts to, again, help build kind of the culture around that policy. Otherwise, the policy isn't going to, it's not going to be as effective.
Yeah, I think you know that certainly from a G3ict perspective, procurement we see as a real key to making an accessible, inclusive digital transformation, including in justice systems. And so adopting a law like Section 508 here in the US by justice ministries around the world, I think would have an enormous positive impact. So with that, I want to thank you, Fred and Michael and Laura, for being a part of this conversation and really leading some interesting perspective on how we can be looking at access to justice for persons with disabilities and improving that, including through technology. I would like to encourage those of you who joined us to think about ways that we might be collaborating. Certainly feel free to reach out to G3ict as we continue to work in this space along with partners like we have on the call today. And I think my colleague Yulia will put into the chat an email address that if you're interested, please do reach out. We see the real solution to creating sustainable progress moving forward on inclusion and accessibility and access to justice is when we bring together civil society along with industry and government to come up with those solutions together. So thank you very much and enjoy the rest of CoSP. Laura, Michael, and Fred, thank you so much.
Thank you, James. Thank you, everyone.
Thank you, James.
Yeah, it was my pleasure. I hope we hit everything you had in mind. I learned a lot. So thank you for including me.
Absolutely. In fact, I was taking notes and I'll be following up with all of you with some ideas and possible kind of next steps. Lots to do.
Yeah. All right, all. Have a good day.
Yeah, thanks. Feel free to check out. I'm going to hang out for just a minute, just in case there's any last questions or anything.